Hi, my name is Andrew Meinzer of Meinzer Law Firm. This is the second video of a three-part video series. The video series pertains to notice of court hearings in the probate division of the Los Angeles County Superior Court in California. There are a few different ways that you may need to give notice of a court hearing. 1. Mailing notice of hearing. 2. Causing personal service of a citation. And 3. Publishing notice in a local newspaper. You need to let everyone with an interest in your petition know about the court hearing. Normally you do this by mailing to them either a notice of hearing, decedent's estate or trust, or a notice of hearing, guardianship or conservatorship, depending on the type of case. These are pre-existing forms. You cannot mail the notice of hearing yourself. You must have someone else who is at least 18 years old mail it for you. That person also needs to complete and sign the proof of service by mail portion of the notice of hearing. The notice of hearing needs to list the name and physical address of all of the people interested in the petition and the case. Technically, you're required to mail to their physical addresses and not to any post office box. Nevertheless, sometimes the court doesn't enforce this requirement. It's a good idea to include a copy of your petition when mailing the notice of hearing and send that out to everybody too. The notice of hearing documents indicate that doing this is an option and not a requirement. Nevertheless, the probate division in Los Angeles County often requires it, so it's a good idea just to send the petition with the notice and then you don't need to worry about having any problems later in that regard. After the person who did the mailing signs the proof of service by mail, then file the notice of hearing with the probate court. The court's going to be looking for it prior to the court hearing of your petition. It's different if you filed a pleading such as objections or an opposition to a petition filed by someone else. In that case, you don't need to mail a notice of hearing document. That person who filed the initial petition was required to mail that. So that informed everybody of the court hearing. That was not your responsibility. You still need to ensure that everyone is aware of your objections or your opposition to the petition, and you do that by mailing a copy of your objections or opposition to every person interested in the petition. You especially need to mail it to the person who filed the petition. They need to know that you have a problem with what they're asking for. And the person who does this mailing of your objections or opposition needs to be, again, somebody other than you who is at least 18 years of age. You'll need to have that person sign a proof of service of mailing, and you need to file that with the court, because again, the court's going to be looking for that before the hearing. Ensuring that you've let everyone know about the court hearing of your objections or opposition or your petition can be tricky. If you do it incorrectly, then the court will need to continue the hearing to a later date. It'll need to give you another try to get things correct. Even worse, the court could dismiss or deny your petition or your objections or opposition altogether. Hiring an attorney with experience in the Los Angeles Superior Court Probate Division helps to avoid all these problems. Again, I'm Andrew Meinzer of Meinzer Law Firm, and we have 20 years of experience in the probate division of the Los Angeles County Superior Court. If you need our help with any of these things in the probate court, or even if you just have a question, please give us a call and let us take care of you.